Welcome back, and now on to another big story of the day. There were three historic bills that were proposed today by the union government, which seek to change and overhaul how the criminal justice system here in India functions. This is largely about the codification and the recodification of the Criminal Procedure Code, Indian Evidence Act and the Indian Penal Code. The argument of the government is the manner in which the codification of Indian laws has happened has a huge colonial baggage. It must be done away with. Not just the optical change or 302 being shifted to being some other provision of the Constitution, there are real substantial changes that have been proposed by the government. Many would argue these are progressive changes that should have been brought in. For instance, whenever an offence of rape is committed on a girl below the age of 12, the punishment can be death. Now, this is something that we have never seen before under the Indian Penal Code. Offence of mob lynching, which was a demand of the opposition parties and various civic rights groups, has been introduced. This was also the suggestion of the Supreme Court of India. And most importantly, and the much talked about, 124A, disaffection against the state, sedition. The offence of sedition will be done away with. It's already in abeyance by the Supreme Court of India, but the fact that it exists on the statute book and is yet to be officially repealed is a proposal that the government is making on the floor of the House. All these three crucial bills have been referred to a select committee now, which will take a view on this matter. But if implemented, eventually passed by the Parliament and given an assent by the President, this is the biggest sweeping reform and changes that we will witness in the history of independence India. And more importantly, the manner in which our judiciary functions, the Indian Penal Code functions, and how trials happen in this country. All of that will be changed for good. Our focus on Viewpoint.
तीनों कानूनों में गुलामियों की निशानी से भरे हुए कानून, राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं, कंप्लीटली रिपील। यहां लोकतंत्र, सबको बोलने का अधिकार है। राजद्रोह को हम कंप्लीटली रिपील कर रहे हैं। मान्यवर, सबसे पहला चैप्टर इसमें आएगा महिलाओं और बालकों के साथ अपराध।
Let's break it down for you. What are the key differences that exist? 124A, the offence of sedition, and the new chapter 7 that has been introduced by the government, the proposed chapter under the Indian Penal Code. Is it only a change of name that you're not calling it sedition and you're now calling it offence against the state? I argue otherwise. One of the key things under the old sedition law was the manner in which it was worded. There were words like feelings of disaffection, hatred or contempt. These are vague, arbitrary words which the Supreme Court argued are open to misuse and should be done away with. Under the new law, there is a thorough codification process which has been proposed by the union government. This is about attempting to wage war and also organizing some kind of rebellion against the state that's going to be penalized. Under this, there are clear heads and sections that have been put out. As I said earlier, there was no clear definition of what the offence against the state was, and hence a cartoon could be an offence against the state. A stand-up comic can be persecuted for sedition. That won't happen anymore. Conspiracy and use of criminal force against the government. Clearly, in the provisions which have been proposed, it is clear if you read those provisions, there has to be a tangible use of force. There has to be some activity that has been done. A mere thought, disagreement, dissent cannot be covered under the proposed law. That's what the argument here is. Section was termed as vague and arbitrary by Supreme Court. It wasn't a judgment per se, but these were oral observations. And under these observations, the law was put in abeyance by the Supreme Court of India with the assurance from Solicitor General that the government is going to relook at these laws. Now, attempt to excite armed rebellion, fueling separatism or separatist tendencies, more importantly, organizing any kind of financial means, using weapons against the state, trying to disrupt the office of the governor or the president who are responsible for the internal security of the country. All of those offences are covered under the proposed law. As I said, the old sedition law is open and prone to misuse due to the colonial language It was something that the British Raj had imposed to protect themselves against the revolutionaries or the freedom fighters of this country. Hence the word disaffection, contempt or hatred. Well, you can have feelings of disaffection or hatred for a particular government or a political party, and you can still be a thriving citizen of this country. That's the spirit of democracy that the new law is trying to preserve and reflect in the new changes that have been brought in. Activities against the president and the governor's office. Now this becomes important because these are heads of the country and the state respectively. Let's move on and also talk about the key changes that have been brought in and what exactly this review is going to be about. Safety of women. One of the things that the Union Home Minister said is that look, 302 or 375 and 376, they are so far away in the penal code and provision, and that is because for the British Raj, the safety and security of women was not really the prime concern. If the overhaul of the Indian Penal Code really happens, there is a death penalty for the rape of minors below 12. We don't have a death penalty for rape in this country. Death penalty exists for rape and murder. But for rape per se, this is being introduced. Minimum 20 years of life imprisonment for gang rape. They are trying to make it more stringent in terms of sentencing. As far as the substantive law in this country is concerned, it's already very good. 2013 Criminal Amendment, post-Nirbhaya, that was already done. What is it that these changes will do? What is the net effect? What is the impact? The government criticism cannot be dubbed as sedition. Just because somebody disagrees with the government and administrative action or something has been said which the government dislikes or people in power dislike, that's not sedition. That is one thing that the law must take care of. There are also safeguards to prevent the misuse of the sedition law that was earlier there. And how is that done? If there is an exhaustive codification of what attempt of waging a war against the state that has been laid out verbatim, that makes sure that it is not prone to misuse. There are exhaustive definitions to cure defects of vagueness. How is a law misused? All laws can be misused, but the laws which are bad per se are whose language is vague and arbitrary and does not define the malice it's trying to target. In this case, the exhaustive definition try to deal with the menace of what was the problem under, say for example, under sedition.